Alaska Packers Association versus Domenico. Court. This case was decided by the United States Court of Appeals for the Ninth Circuit in 1902. Issue. The primary issue the court considered was whether, when two parties enter a second contract, which modifies the terms of the first contract in so that one party is provided with more compensation than originally agreed upon in the first agreement, the second agreement is supported by consideration. And the court ultimately held no, the second contract lacks consideration. Facts. The facts of this case are as follows. The plaintiff, or appellee, was Domenico, a group of working sailors and fishermen. The defendant, or appellant, was Alaska Packers Association, a large canned salmon manufacturer based out of San Francisco, in search of a group of sailors and fishermen to work throughout the salmon fishing season. The two parties entered into a contract, which we will call Contract Number 1. Under Contract Number 1, the group of sailors agreed to board a vessel chartered by the manufacturer, sail from San Francisco to Alaska, salmon fish throughout the salmon season, deliver the salmon to the manufacturer's Alaska cannery, and then return to San Francisco. While aboard the ship, they agreed to perform regular ship duties, as well as whatever other duties requested by the captain. In return, the manufacturer agreed to pay each sailor $50 for the season, as well as 2 cents per salmon caught. 2 months into their performance, a group of sailors decided that they are not being paid a fair wage and stopped working entirely, threatening to return home to San Francisco without fulfilling their obligations under Contract Number 1. The manufacturer tried for several days to get the sailors to work, or find replacement sailors, but was unsuccessful. Because the manufacturer had invested $1,500 into the Alaskan cannery with the expectation that the sailors' performance of Contract Number 1 would yield substantial profits, it saw no choice but to give in to the sailors' demands. The manufacturer modified the original contract, creating what we will call Contract Number 2. Under Contract Number 2, the sailors' contractual obligations did not change, but the manufacturer agreed to increase each sailor's pay from $50 to $100. When the salmon fishing season ended, the manufacturer refused to honor Contract Number 2 and instead paid each fisherman the compensation agreed upon in the original contract. The sailors sued. The trial court ruled in favor of the sailors, however it was primarily for a reason unrelated to the issue of consideration. So, the manufacturer appealed to the Court of Appeals for the Ninth Circuit. Again, the issue being considered here was whether Contract Number 2 lacked consideration, considering that the sailors had downright refused to perform their obligations under Contract Number 1, despite the detriment that their refusal caused the manufacturer. Analysis. The Court of Appeals ultimately held that it did. In reaching its holding, the court reasoned that the sailors did not have a valid reason for refusing to perform under the original contract. Because of this, the sailors' refusal to perform constituted a willful breach, for which the manufacturer was entitled to damages. The court further reasoned that the manufacturer only entered into Contract Number 2 out of necessity, in that it did not gain anything that it was not already guaranteed under Contract Number 1. While the manufacturer was obligated to pay the sailors twice as much money under Contract Number 2 than was originally agreed upon, the sailors' performance under Contract Number 2 was virtually unchanged. Because of this, the court held that Contract Number 2 lacked consideration and reversed the holding of the lower court. Rule to remember. The rule to remember here is that there can be no consideration for a modified contract that arises from a coerced promise for a pre-existing duty that one was already contracted for.